So we have answer according to ABA and California authorities, which gives it to you. And we have Len, lawyer Len. Len, an attorney, is a member of Equal Ownership, Inc. Equal, a nonprofit organization that seeks to help low-income families purchase homes throughout the state.
All right, by member, I presume they mean member of the board, which basically is a significant role in the nonprofit. He has confidential information and duties to the corporation at this point.
Len does not represent Equal as an attorney.
That's okay. He doesn't have to. He still owes duties to Equal.
Equal helped to get a statute enacted that requires that all new residential developments contain a certain percentage of low-income housing.
Okay, so again, in order to get that statute, there's likely to be confidential information that was gathered that Len would be privy to.
ABC Development Corporation is a corporation that wants to challenge this statute.
Well, ABC is directly adverse to Equal then, isn't it?
Yeah. Pat, the president of ABC, asked Len to represent ABC, and Len agreed.
All right, well, we've got to stop right there. And I think that's low-hanging fruit, a pretty simple concurrent conflict of interest, a violation of the duty of loyalty. A lawyer shall not represent a client if that representation involves a concurrent conflict of interest, where a concurrent conflict of interest would be representation directly adverse to another client, and in this particular case, representation of ABC is directly adverse. Now note that this is not another client, so we'd have to say this one doesn't quite apply, but we discuss it, but then we'd want to go on to the next part of the rule. And what
the
does
next
that
part
say?
of the rule is that there's a significant risk of material limitation on representation because of the lawyer's responsibilities to another client, a former client, a third person, or the lawyer's personal interests. And I would say that Equal Ownership, Inc. is a third person.
Yeah.
Besides which, his interests have to be adverse as well. Why would he be a member of an organization that's trying to ensure new residential developments contain low-income housing if that wasn't a personal interest of his?
Yeah, and I think we're going to find that it was a personal interest of his, and so the plot thickened.
Len does not personally agree with ABC's objectives.
Okay, that's okay. You don't have to agree with your client's objectives as long as you can be a zealous advocate.
But moves forward with the representation nonetheless by filing a complaint challenging the statute.
I'm okay with that.
Len personally thinks the statute is a good law and secretly hopes that ABC is not successful in its lawsuit. So they're telling you that it conflicts with his personal interests.
Yeah, I'm not okay with that. And by the way, when I said I was okay with just filing the complaint, I'm taking that in isolation. Of course, he has a concurrent conflict of interest, so it's still not okay. But just because he disagrees with the objectives, that's not a professional ethics violation. You can take those cases on. So here he thinks the statute is a good law, and now he secretly hopes ABC is not successful. He's betting against himself. All right, he's got a duty to be a zealous advocate. He has an undivided duty of loyalty to his client. He's breaching that, and this I don't like.
During the course of Len's representation of ABC, Pat informs Len that he, Pat, has filed false reports with the State Environmental Protection Agency regarding the disposal of non-hazardous waste, and is planning to file another false report next month.
Okay, now again, we have to look here. Who is Len's client? And the answer is ABC is his client. So this is an issue of organization as client. And the rule is he has to represent the best interests of the organization, and he's required to explain his identity of organization as client when he knows or should know the organization's interest or adverse. In this case, we've got Pat, the president, saying he's violated the law here. That could certainly impair the corporation. So he's got a problem here, organization as client.
Filing a false report makes a person and his or her employer liable for a substantial civil fine.
Okay, so there's consequences. Therefore, he's got a duty under ABA authorities. He must ask for reconsideration, advise for a second legal opinion, refer the matter to a higher authority. That would be the board. And, well, he can resign, but he can't blow the whistle unless necessary to prevent substantial injury to the organization. And
So it says a substantial civil fine, and I think they put the word substantial in there to allow you to argue that it is substantial injury to the organization.
yeah, you could have argued that.
So under ABA, Len could blow the whistle.
Now, in California, you could not. And that may have been a distinction they wanted you to talk about.
Now that goes on to say Len does not take any action with respect to the impending filing of the false report.
Well, what they're trying to do here is trick you into saying, wait a minute. He's allowing this non-hazardous waste. Well, it's non-hazardous. He's allowing it. He's filing false reports. He's got to do something about it. And the answer is the issue is confidentiality. And really, there are no situations where one must breach confidentiality.
However, his duty to the organization, which is his client, is to go up the ladder.
Mm-hmm.
So the fact that he didn't take any action, I think, is a violation in that he should have informed the board. He should have moved up the ladder.
Okay, I think that covers the big issues that should have been on your radar.